So thank you very much. That was well worth the trip. So thank you for the very kind introduction. I appreciate it. It's a pleasure to be part of the Global Water Institute's Water Issue Commentary Series. And before I begin, it probably makes sense for me to thank a number of people. Of course, to Greg Leslie, to Cameron Hawley, who I haven't met, but I think emailed quite a bit with. So thank you for inviting me. I want to thank Lisa Episcopo, if she's here, for arranging everything. And then I also want to send a special appreciation to my longtime colleague and good friend, Roz Dixon. She made all of this possible, so I appreciate you connecting me with everyone, Roz. So I'm excited about talking about this topic with you, and it's a topic that's really captured my interest, and it's one regarding Egypt and Ethiopia and their division of the Nile's water resources. As Greg mentioned, I first wrote about this in 2014, and it's always a risk, I think, to publicly evaluate one's own claims 5 years later and see if I made any sense back then and see if how developments today match what I thought might happen. So I look forward to talking to you a little bit about how I viewed the problem then, how I view it now, and to see if the claims that I made then make sense today, and then offer some thoughts for the future. So let me kind of give you a bit of a roadmap to how I'm approaching it. One, I'll say a little bit more about the motivation for the project. Second, I'm going to offer a couple, we'll call them frames, maybe ways of thinking about the particular issue. Third, I'll kind of go into the international law and really think about what the doctrinal debates are regarding international water laws applied to the Nile and Egypt and Ethiopia's competing claims. Then finally, I'll apply the kind of economics approach that I've referred to and see where we are now. How does that turn out? So as Greg pointed out, international water law is not at the core of what I've been doing, but it's something I've been doing more and more recently. I generally write in the area of constitutional law of foreign affairs. So this is an area in the United States which basically looks at the relationship between the president, Congress, and the courts, and how the U.S. conducts itself in foreign affairs. And I would do so from a perspective of incentives and institutional design. I also would look at how the U.S. engages with international institutions, and I use the same kind of frame. So during that period, I started to think more and more about how we might think about incentive-based approaches, just to thinking about areas where institutions are weak, like, for example, East and North Africa, and then areas dealing with natural resources, and again, thinking about water. So incentives, institutional design, areas with weak institutions, combined with debates about natural resources. Now, the particular idea for approaching Ethiopia, Egypt, and the Nile came out of a symposium where I was thinking about the economic foundations of international law. It was a book by two colleagues. And their claim was that economics thinking, that is focusing on rational choice frameworks, thinking about incentives, thinking about reputation costs, can serve not only as a basis for international cooperation, but also help us think about the enforcement of international law. This might sound somewhat straightforward. How is this novel? How is this particularly interesting? Well, it's important to think about it kind of in contradistinction to what is arguably the dominant approach of thinking about these questions. And that approach is really considered a legalist or a doctrinalist approach. And that's where you basically look and evaluate international water law, look at the treaties, look at the different conventions, look at the cases, and evaluate them independent of the incentives of the different parties. So just what would the law say without necessarily embedding that assessment in what the actual political or economics, political framework or the economics of the situation. So as someone who is, inclined to thinking about incentives and inclined to think about institutional design, and I admit I'm somewhat more skeptical about heavily doctrinal approaches to thinking about international law, I was intrigued by thinking about economics in terms of Ethiopia, in particular in terms of the Grand Ethiopian Renaissance Dam. So I thought about this as really a test case for thinking about how economics might work in the context of international water law. And I should say, for fear of being accused of being biased, my parents are Ethiopian, though that has no effect at all on the paper. Take it as you wish. But it was interesting as I started writing about it. I would look at the people who've written in the area, and half are Egyptian and then half are Ethiopian, and you can kind of guess where they end up on the different views. So we'll see if I end up in a similar place. Okay, so what is important to think about this? Well, first it's important to think about what their respective legal claims might be. How is Ethiopia approaching this question? How is Egypt approaching this question? And then what would an economics approach tell us? You know, is there something unique that we can get out of it? Or is the situation with the Nile and Egypt and Ethiopia just too sui generis? Meaning this is a unique situation for reasons I'll explain, and it's hard to make any sort of generalizable predictions about the power of international water law to actually constrain state behavior. So my intuition is that international water law will not be helpful here. It will not be useful in helping us think about the division of the Nile. Why did I come to that conclusion? So for a few reasons. One, both countries are highly dependent on and in need of the Nile's water resources. Second, the lower riparian state, that's Egypt in this context, is much more powerful than the upper riparian state, that is Ethiopia. And then third, neither country has a real record of complying with international law. So the conjecture is that they won't really be motivated by legal arguments. One is more powerful than the other. They really, really need the water, and they have no reputation or history for really complying with international law. On top of that, we live in a world with no central enforcement mechanism. That is, there's no global police person coming around to help enforce international law. So what will really shape the outcomes here, whatever happens between Ethiopia and Egypt, well, it'll either be state power, it'll be the cost of transactions between them, and then the incentives of the different parties. That will shape it. Now I want to add two additional frames for thinking about it. One is asking the question, under what circumstances do we think that international water law is likely to shape how states behave? So we might think about it along a continuum. There's some instances where we think international water law might constrain them. There might be other instances in which we don't think so. So that's one thing to think about as I continue. Second is to think about whether international water law is increasingly regulating an area that's really national security. And if it's regulating an area that's national security, it's not an area in which international law traditionally has a lot of power. Because when states are really driven by national security concerns, international law isn't really going to constrain it. And then third, do we think that Ethiopia and Egypt will really act consistent with an economics or an incentives-based approach? And that's where I'll start by providing some background. So what's the background? How important is the Nile to Egypt and Ethiopia? So first, unsurprisingly, you all know that the Nile is the world's longest river, consists of two main tributaries, the White Nile and the Blue Nile. The White Nile begins in Lake Victoria, basically around Tanzania, Uganda, and Kenya. The Blue Nile begins close to Lake Tana in Ethiopia. The White and Blue Niles basically meet around Khartoum and then flow north into Egypt. So that means that the Nile is an international watercourse. This is a legal term, which means that particular conventions apply to the division of its water resources. And there are 11 countries in the Nile River Basin. So there are two downstream countries. Unsurprisingly, that would be Egypt and Sudan. There are some midstream countries. That would be the newly created South Sudan, Eritrea, Rwanda, Burundi, and the Democratic Republic of Congo. And then there are the upper kind of upstream states. Obviously, Ethiopia would be one, Tanzania, Uganda, and Kenya. So those are the 11 countries that are most affected by it. So how important is the Nile to Egypt? So let me give you a few facts here. So the Nile provides 96% of Egypt's renewable fresh water. 96%. It hosts something like 98% of Egypt's 99 million people, and that's in the Nile Valley. And then even more close, 95% of those live within 12 miles of the Nile. The Nile provides 86% of Egypt's fresh water for agriculture, and agriculture represents about 12% of Egypt's GDP. On an annual basis, Egypt needs about 105 billion cubic meters of water to cover the needs of its people. It currently has about 60 billion cubic meters of water, and 55.5 billion come from the Nile itself. The remaining 4.5 come from subterranean water sources. So basically, Egypt already has an enormous water deficit, and depending on how you calculate it and what you consider sufficient to cover its needs, that water deficit really ranges between 20 and 40 billion cubic meters per year. Egypt estimates that a reduction of 2% of the Nile will lead to the loss of 200,000 acres of land and 1 million jobs. Now, that's an Egyptian estimate, may or may not be accurate, but that's their estimate. So clearly, the Nile is hugely important to Egypt. Now, how important could the Nile be to Ethiopia? And I phrase it as could the Nile be to Ethiopia, because at the moment, Ethiopia uses something basically approaching 5% of the Nile's river basin, when it constitutes something like 70% of the available water resources for Ethiopia. So just look there. So you have basically Egypt relying on it for 96% of its fresh water, Ethiopia, where the Nile begins, and Lake Tana, using it for less than 5%, even though it represents 70% of its water resources. So it's not as if it can pivot easily to other sources that are as important as the Nile. So given that, what did Ethiopia do? So it commenced this the Great Ethiopian Renaissance Dam project in 2011. It's about a $5 billion project. And the idea is to build one of the world's largest hydroelectric dams. As of April 2019, after a number of delays, it's now scheduled to be complete in 2022. It's currently about 2/3 to 70% complete, and it's expected to have 6,000 megawatts capacity. It's a 6,000 megawatts capacity dam. What does that mean? Well, it would make it the largest hydropower dam in Africa. And to give you an idea of scale, the Three Gorge Dam in China is the world's largest with respect to full capacity, and that's something at 22,500, to give you an idea. The largest in the United States is the Grand Coulee Dam at about 6,800. So while it'll be the largest in Africa, it'll be one of the top 20 in the world. So this is not a small undertaking. And for those of you who have greater expertise in building a dam than I certainly do, it's basically a 1.8 kilometer high gravity dam with a 5 kilometer kind of rock-fill saddle dam to create a reservoir, and then a 300-meter long spillway between the main and the saddle dam. And it's located naturally about close to the Blue Nile, which is basically built around 20 kilometers from the Ethiopia-Sudan border. All right, so Ethiopia is moving forward. It's moving forward with some success. How have the issues been managed, let's say, between 2010 and 2014? I use that period because it marks basically the first phase of its development, and there have been some acceleration of developments between 2014 and the present. So naturally, Egypt and Ethiopia came together with the other 9 countries, and they created what's called the Nile Basin Initiative, and this produced a cooperative framework agreement. I say cooperative kind of advisedly, or in air quotes, so to speak, because the agreement was basically that the upper riparian states would use more of the Nile. Unsurprisingly, Egypt and Sudan rejected that immediately. I said, this doesn't make any sense. And Egypt decided to take additional steps. So historically, whenever Ethiopia has talked about building a dam, Egypt is talking about blowing up dams. So this goes back to Anwar Sadat, actually, when Ethiopia first thought of doing it. There they started to develop some resources to build a dam, and one of the ships carrying many of the key materials, unfortunately, was sunk. It's unclear what happened, but the Egyptians were not too disappointed. And then more recently, the first and only elected president in Egyptian history, that was Morsi, if you remember him. He was president for a short period. He was caught on, on live mic, and he didn't realize it, talking about how if the Ethiopians ever were to build a dam, we would just bomb it, and that would be very easy. So it's not really worth engaging in these negotiations because the Ethiopians don't have a great air force. We can fly in, blow up the dam, and they're not going to waste a lot of time building it. So this was the kind of context in which Ethiopia was building the dam, and they're moving very slowly for fear of Egyptian reprisals. All right. So given this kind of background, and I can go into detail about the back and forth with Egypt and Ethiopia, but I think you get the general context. What would international law say? So how, when two countries are threatening one another, at least one is threatening the other, and to be fair to Egypt, Egypt looks at the building of the dam as a national security threat. It's a threat to them, so it's not just one-sided. What would international law say? And, how would we look to international law doctrine to help us out? So luckily, in international law, there's often a convention addressing everything, and there's a convention here that's nicely named. It's the Convention on the Law of Non-Navigational Uses of International Watercourses. I'm sure all of you look at this convention quite regularly when you're suffering from insomnia. In particular, it really works. It was concluded by the UN in 1997. It required 35 countries to sign to come into force, and so far only 34 countries have signed. And unsurprisingly, neither Egypt nor Ethiopia is a party. Now, that's not a problem for international law, because many times treaties or conventions basically serve to memorialize what is the existing custom among states. So this is often called customary international law. And these are basically the practices among states that over time have crystallized and that states follow out of a sense of legal and moral obligation. So the view is that even if the parties are not signatories to the convention itself, it actually reflects what the existing customary international law is, to which all countries are bound. So what does the convention say? What's most relevant for the convention for our purposes? Well, it rests on two core principles. Principle one is about the idea of equitable and reasonable utilization of international watercourses by the riparian states that are going to exploit the watercourse. So in other words, it says, you know, be fair, be reasonable in your use. That's Article 5. Article 7 has other language that might be viewed in tension. That says there's an obligation not to cause significant harm to other states sharing the watercourse. So just if you stop right here without looking at anything else, you have an interesting dynamic here. Almost any use of the water by Ethiopia, per the Egyptian, would cause significant harm. But when 70% of the water resources are in Ethiopia, and you're only using less than 5%, it would seem equitable and reasonable to exploit some part of it. So right there, you have a lot of ambiguity where either party can argue, I think quite forcefully, that Article 5 or Article 7 protects it, or at least protects its position. So what is the Egyptian argument? So it basically has four components. First, they say, look, in 1902, Ethiopians, you always remember 1902, because that's when Ethiopia and Great Britain negotiated a treaty. In this treaty, the position of the Egyptians is that Ethiopia disclaimed any right to Nile's water resources, and then committed not to reduce the annual flow of the Nile or any of the water resources available to Egypt. So you might say immediately, why are we talking about Great Britain and Ethiopia? You know, obviously at that time, Egypt was a protectorate of Great Britain. So indeed, Egypt would serve arguably as, in law, you'd say, a third-party beneficiary of the agreement. The agreement was designed to protect Egypt's interests going forward. So that's argument one. Argument two is just reference to Article 7. As you look at the convention, 1997, it basically stands for customary international law. And given that, you can't cause significant harm, and this would cause significant harm to to Egypt. Third, there's something called the appropriation doctrine. And this is something for those of you who are interested in John Locke and others. It's the idea that if you are the first to exploit, or you're the first to use some amount of water for a beneficial purpose, then you have an exclusive property right as to the amount of water used against any subsequent user. So Egypt will say, not only have we been using it recently, we've been using it for thousands of years, and we've been using all of the Nile. So any subsequent user to come and say, look, you have no claim here, because we have thousands of years of use, and by the appropriation doctrine, we're the first user for a beneficial purpose. So thank you, Ethiopia, Sudan, or any other upstate or upper riparian country, you have no claim. And then finally, and this is it's a bit of a puzzle why they make this argument, they say, well, we signed these agreements in 1929 and 1959 with Sudan. And Sudan agreed that they wouldn't exploit the water. It's not clear at all why this would matter for Ethiopia, but this is an argument they tend to kind of bring out. So these are basically the four claims Egypt makes. What does Ethiopia say? Ethiopia says, well, this 1902 treaty with Great Britain, well, this was never ratified by Ethiopia. So some countries have a process where you have to sign a treaty, but then you have to bring it to your Congress or bring it to your parliament for formal ratification. They say, well, we didn't ratify it. This is often a move used by many countries. Oh, do you think that was enough? We actually need a ratification, sorry. The second argument is that, indeed, that there are competing meanings in the treaty. And this is something that arguably, this is something that's come up in Ethiopian history with respect to treaties with European countries, and it's not clear who's in the right. So they say the Amharic translation does not say that we disclaim any right to the Nile. Why would we ever sign a treaty saying this? I don't know what the English version says. This has also happened with respect to Ethiopian agreements with Italy, for example, regarding the creation of Eritrea, where there's an Amharic version and there's a, we say, a European version that seems to be different than what was negotiated. They then have, the Ethiopians have their own version of an appropriations doctrine. It's called the Harman Doctrine, which basically says that jurisdiction over natural resources by a sovereign in its territory is exclusive and absolute. Exclusive and absolute. So the water is here, it's in Ethiopia, it starts here, we can build a dam because our sovereign right's exclusive and absolute. This is obviously in tension with the appropriations doctrine, which talks about a first user. So you can see where international law gives a little bit to everybody, so to speak. They then look to Article 5, which says inequitable, reasonable use. You can see the arguments there. And then, of course, Ethiopia says we were not parties to these agreements with Egypt and Sudan, so why does that have any ability to shape our legal rights? So stopping here, you see the structure of the legal argument. You see what the countries are going to argue. So how would this get resolved if we're in the legal world? How does this get resolved? Well, some court, some international court or international arbitral body would have to consider these treaties, interpret them, look at the appropriation doctrine, look at the Harman Doctrine, look into the evolving custom under international water law, look to the international water law jurisprudence that you might see out of different countries and courts. If you were to just focus on Article 5 and Article 7, you could see there's a lot of ambiguity there, so it doesn't give you a definitive answer. And then even if you manage to do all of that, there's some international arbitral body that makes some determination after carefully looking through the legal materials and listening to the parties' different claims. It's not clear there's any enforcement mechanism for this agreement or this decision by any court. And it's not clear that either country would respect it, given how core these issues are. You might say, well, Ethiopia might be a little bit more likely to respect it than Egypt because they're not already dependent on the water. So another way of saying it is they're already very poor, so that things can't get any worse. Egypt would say, gosh, this is a terrible situation because we already dependent on it. A more complicated version would be Ethiopia's population is exploding, its water dependence is increasing, and it cannot just continue to say, you know what, there's some first user doctrine Egypt was using beforehand. This is actually a real national security threat, and I'm bracketing climate change for a moment, but that's yet another reason. So stopping here, what have we gotten out of this? Well, we understand why it's important to Egypt. We understand why it's important to Ethiopia. And we see what the relevant legal materials are that would help us try to resolve the question. I don't find that this is a particularly fruitful way of looking at it. It's not wrong, and it doesn't necessarily serve as a bad point of departure, but it doesn't give us anything prescriptive. What should we do? Or if we were a social planner, what's the right outcome that maximizes welfare for the two countries? Or more broadly, how does it maximize welfare for the world, right? Or the 11 countries, at the very least, that are part of the Nile River Basin. So then the question is, well, all right, you say the law is not working, then what is this economics approach? Why would that be any better? So let me outline that, but let me start by saying or sharing a few assumptions that inform this. So assumption one is that these two countries are basically rational states, and they're pursuing their self-interests, and they're doing so in a world where they know there's no global police person to enforce the rules. So you're pursuing your incentive, you're pursuing your preferences, knowing that there's no one who's necessarily going to come in and stop you. Now you might say, well, then great, you do whatever you want. Well, it's not that simple, because while both states might want to ignore international law and say, no one's going to stop us, we're going to do whatever we want, well, we know that there are reputation costs, there's a risk of retaliation, there's a risk of sanctions, and you know you have to deal with other countries over time. So if you build a relationship, or excuse me, a reputation for non-compliance, no one's going to want to work with you. And then third, the assumption is that while both states clearly have different preferences, in an ideal world, they both value the Nile and they would benefit from cooperation. Another way of saying it is they would love to come to a conclusion, a cooperative solution that maximized their own preferences, right? Why wouldn't they if they could do it that way, rather than resorting to other forms of solutions? All right, with that in mind, let's see how some simplified economics might work here. So There's something that's common at the University of Chicago. It's basically transaction cost economics. And it comes from an idea that was developed by a faculty member at the law school, Ronald Coase, who died maybe 6 or 7 years ago. He's the only law professor to win a Nobel Prize in economics. And he had a number of intuitions, but he had one core kind of theorem. And the idea is that if transaction costs are low, that is the ability for two people to come to an agreement over a topic, if those costs are low, then the entitlement, the legal rule, will flow to the party that values it most, no matter where it's initially assigned. What does that mean? So let's say that there are two parties concerned about, they want some land. They really want some land. It doesn't really matter if the court gives the land to one party or the other, because whoever values it most will go negotiate with the other party and buy the land. Now, it assumes that it's easy for the two parties to identify one another, that they're willing to negotiate, but law doesn't matter in this story. You assign the right, and then it will flow to whichever party values it most, because they'll engage in a welfare-enhancing transaction. They'll pay. So let's think about this in terms of Egypt and Ethiopia. So let's assume today that the property right were assigned to Egypt. So Egypt had an exclusive right to the water. So if Ethiopia valued it more, Ethiopia would pay Egypt for the property right, and it would build the dam, and it would exploit the Nile. Now, in theory, this would be what we would describe as an efficient outcome, because the party that values it most will have paid for it and been able to move forward and exploit the water. Egypt would be getting dollars that it valued. Ethiopia would get the dam. Now, of course, water and dollars are not commensurable, but conceptually, it would be welfare enhancing. However, what do we know in practice? In practice, we know the transaction cost between these two countries is enormous, right? We know, for the reasons I've described, the political and financial costs are very high. So it's unlikely the countries would come to an agreement. Plus, there's no way to enforce it even if they did. So where does this leave us? It leaves us with what we would describe as an inefficient or a suboptimal outcome, because Egypt has the property right, and Ethiopia couldn't do anything at all. Meaning it can't use the Nile, can't exploit it. And that's suboptimal. That is suboptimal. There's another way of thinking about it. Think about it in terms of what we call liability rules. And let me explain what that is. So rather than Egypt having an exclusive right that Ethiopia would have to pay to exploit the Nile, it would be that Egypt has an entitlement to do it, but if Ethiopia wants to build a dam, they would just need to pay the damages. They don't have to go and negotiate up front to figure out what Egypt's cost is. They just build the dam, and if it reduces the flow of water, they pay Egypt the cost. So what would be a version of this? If indeed the dam is built and it causes some damages at a certain amount of money, Ethiopia annually would write a check. But it would there would be no property right that Egypt has. So it couldn't stop Ethiopia from building a dam and doing it. It would respect the fact that it would get this annual payment. But this liability rule runs into the same problem as the property rule. That is, while we don't think Egypt and Ethiopia could reach an agreement on, what the cost would be to buy the right to exploit the Nile in the property instinct, in the liability rule, how would they value the damages? Right? So you have the same set of problems because the valuation of the damages is very high, or very hard to do. And then, of course, there's no enforcement mechanism. So then you think we're kind of stuck. We can have this conceptual frame of who should have the right and who doesn't, but it's not getting us anywhere that the international law approach wasn't getting us either. So why is this helpful? Well, what was the status quo in 2014? So in 2014, basically Egypt has the property right, and it exploits the Nile. It's using all of it, right? And Ethiopia is tentatively, or was tentatively at that time, building the dam. And they were trying to utilize the water resources, but without paying any price to Egypt. They're like, we're going to build the dam. So what do we have here? It's a clear formula for conflict. Because Egypt has the right, Ethiopia is building the dam, and it's not suggesting it's going to pay Egypt at all. This is the formula for conflict. But there's another way to think about this, where economics can be more helpful. Let's assume that Egypt has never used the water and Ethiopia has never built a dam. So we're starting in time one. We have the Nile, and you have the two countries. So there's no prior dependency on either side. So how would we think about this? If Egypt had the property right, well, Ethiopia wouldn't invest in the dam at all because it could be stopped from building it. And the damages from invading the property right of Egypt would be so high that it would exceed the benefit of building the dam. And if it exceeds the benefit of building the dam, this is a suboptimal outcome because Ethiopia is getting zero and the pie could be bigger for both countries. But if Egypt, in the first instance, just had the entitlement to use it, protected by the liability rule I was describing, Ethiopia would then pay Egypt for the harms, but it would keep any excess benefit, right? So Ethiopia doesn't build a dam unless the value after paying Egypt for the damages also creates value for Ethiopia. If that's the case, that would be optimal because then Ethiopia is getting value from the dam and the value is so high it's able to pay Egypt the costs. Egypt's getting some of the water and the amount that makes it whole, and Ethiopia is able to exploit the dam. This would be the efficient or optimal level because it would leave both parties better off. So what does this do? Well, international law does not leave us with any sort of normative or prescriptive claim, but this kind of economics approach does. It's a weak one, but it basically says Ethiopia should build the dam, pay the cost of any harm to Egypt, and then keep the excess revenue. If there is no excess revenue from the dam, it shouldn't be built at all. And presumably Ethiopia has done this calculation. Presumably. All right. That was the prediction, or at least that was the soft prediction I was thinking about in 2014. That's what I basically had said then. All right, what's happened since then? So this is when you get to embarrass yourself in front of an audience. All right. Tensions remain high between Ethiopia and Egypt, but there's been a change. Sudan now has taken a position more aligned with Ethiopia. Before, it was aligned with Egypt. Taken a position more aligned with Ethiopia. And, as you know, there's been regime change in all three countries since 2015. The populations in two of the three countries have really exploded, namely Ethiopia and Egypt, and water dependency has increased. So all the dynamics, all the variables here have not changed, they've only worsened. But they've turned to negotiations. And Egypt and Sudan and Ethiopia have signed, these are agreements that don't have the power of international law, consider them declarations of intent. And what have they said? Well, they've decided to address some of the potential problems from the dam, including reduced water flows, the filling of the dam's operations, and what they would do in the context of dam failures. And what do these agreements look like? And I'll say a little bit something about them. So first, they decided to form an international panel of experts. This is what you always do when the two countries can't agree on each other's experts. All right, so the three countries. So then you got to think about what are the numbers of the experts. So they said, all right, we'll have 2 experts from each country and 4 international experts. All right. So this group got together, and this was in May of 2012, and they produced a report in May 2013 that basically said that the dam adhered to international design criteria, maintained the kind of standards and codes that one would expect, and it gave in practice kind of the basic engineering practices that were consistent with dam creation and building. Now, serious differences, unsurprisingly, arose between Egypt and Ethiopia regarding the roles or the needs for international experts going forward. Ethiopia said, great, we're doing it perfectly, see the report, we're done. Egypt said, no, we need to spend much more time to ensure that over time you will actually stay consistent. So Ethiopia and Egypt got back together again with Sudan, and they signed another agreement. This one is a declaration of principles. They call it the Nile Agreement. This one is interesting because here it starts to incorporate not only bits of how we think about international law, but some of the entitlement and liability rule economics that I was describing earlier. And I'll point out the specifics as to why. So first, they started by saying the colonial agreements which favor the downstate riparian countries are unsustainable. This might seem big, might not be. This is the first time Egypt is saying basically those old colonial agreements from 1902, 1929, and 1959 are basically unsustainable. Why were they unsustainable? Well, it boxed Egypt into a position where they were saying that no one upstream, could ever exploit the Nile. And that's just not a legal position that was going to work, and it's certainly not a position that they were going to find a lot of support from the international community. So they gave up a position that was basically unsupportable, but it was something they gave up. All right, so that's step one. Step two, the Article 2 rules out the use of water for irrigation. This is very important because if it's only used for hydroelectric purposes, then the concerns about the diversion of the Nile, etc., and the annual flow are weakened. Right? If you're using it for irrigation, then there might be a permanent change to the annual flow, or at least that permanent change could be severe. If it's for hydroelectric power, it's a little bit different. And Ethiopia committed that there would be no change in the annual flow. Let me stop here. This is a little bit like Ethiopia paying damages to Egypt. It's basically, rather than saying, you know what, we're going to use the water for irrigation, and we're going to cut the flow, and then write you a check for that cost of that water, they're saying, we just won't do that. It's a benefit in kind. So they're acknowledging that Egypt has some right, but they're saying, oh, we won't do these things. They then added 2 articles that basically said equitable use and no significant harm. So they adopted the international law principles. And then Article 6, interestingly, says that there's a priority for hydroelectric power purchase by the downstream countries. This is another give by Ethiopia, right? It's basically saying Egypt, Sudan, and basically the other midstream countries, we will basically give you a priority on purchasing hydroelectric power, which basically means they're purchasing at a discount, which is limiting Ethiopia's options in selling the power on the market. That's not quite writing a check, but it's basically yet another benefit because they're subsidizing the cost of electricity for these countries, just as they're also committing not to use the water for irrigation. So that's 2 forms of a benefit. Call it damages, call it a check, paying Egypt. Article 10 says there will be peaceful conflict resolution. They always throw those in there. Great, okay. Ethiopia then later committed to take necessary steps to avoid causing significant harm to Egypt and Sudan, to mitigate the harm if it ever happens, and to discuss compensation, quote, whenever convenient, end quote. Which is not a huge give, might not be convenient for 50, 7,500 years, not exactly clear. And the declaration includes no reference to historical agreements or what Egypt's share of the Nile's water should be. So it doesn't take as a baseline what the current use is. It doesn't take a baseline. All right, and then finally, Ethiopia did not commit to reconsidering the size of the dam or the storage capacity of the reservoir. This is an issue because the current plan for the storage capacity is 74 billion cubic meters. And this is a size that many international experts say is technically unnecessary. It's just too much. And this is something that the Egyptians are very concerned about. Okay, so what is the upshot of this? And I should just say there have been back and forth, the machinations between the 2 countries from 2015 to now are quite incredible. Egypt in 2017 wanted to reject the declaration, then it changed its mind again, then it started investing in desalination projects. Ethiopia then accelerated its process of building the dam, but then the head of the Ethiopian Dam Authority actually committed suicide. It wasn't clear why exactly he committed suicide, but he was found in his car. The initial conspiracy theory was that he didn't commit suicide, that the Egyptians got to him. I don't think that's actually what happened, but he committed suicide. Then Ethiopia was upset with the Chinese company that was actually working on the dam, so then it decided to go to a new supplier, so then that caused more delay. And then Ethiopia and Egypt are going back and forth about whether they'll have French or Dutch experts to continue to monitor the guidelines of the procedure. The takeaway is that it's in Egypt's interest to delay, it's in Ethiopia's interest to move more quickly, and these poor, French and Dutch don't really know what they're getting into when trying to deal with Ethiopia and Egypt on this. All right. So what's the upshot? What's the upshot? Well, then let me revisit the three framing points I mentioned at the beginning. I said, well, under what circumstances do we think that international water law will likely shape state behavior, likely shape the behavior in this context of Egypt and Ethiopia? So I think there are three conditions. This might be helpful to think about water law challenges going forward. One is when the states are similar in power. If states are similar in power, then they're less likely to turn to war or to threats, and they're more likely to look to peaceful dispute resolution mechanisms because the returns to threats are not there. Second, it's often helpful when the states have varying need for the water resource. So when both countries really, really need the resource, well, it's unlikely that international law is going to be as useful, because if they really, really need it, then it goes to some sort of core security or economic interest. But if there's varying need among the parties, one needs it a lot more than the other, then there's room for agreement. And you might think that international law would be the place or international water law particularly, the countries would turn to. And then third, you might look at it in terms of when states have similar good reputations for compliance. In this case, the answer is no for all three. They're not similar in power. So you have a country in Egypt stronger than Ethiopia, more inclined to use military means. Second, varying need for the water resource. Now, Ethiopia's need is increasing, but Egypt's need is very, very clear. There's already a sunk cost. There's a huge need there. So there you have you don't have the varying need, and then you have no reputations for compliance with anything among the parties. One way to think of the flip side of this, and this is I just use this to help frame it, is to think of arms control agreements between the United States and the Soviet Union. The states were similar in power in the sense that they both had a nuclear capacity, and they could both destroy one another. They didn't really need any more nuclear weapons because after a certain level, they can destroy one another. And while they didn't have a similar necessarily good reputation for compliance, they could trust and verify. They had verified components. These things just don't exist here in this particular context. So that's the first concern. Well, that's a frame. Well, maybe international water law won't be helpful in these circumstances. Frame number two is when international law starts to regulate more and more issues that deal with national security, it's going to be harder for international law to actually regulate anything. So here's a simple example. You might think when countries are not going to delegate their national security interest to adjudication by some foreign court. Here's an example. When the United States could not get a resolution from the United Nations Security Council with respect to its second invasion of Iraq, the United States, what did it say? It didn't say, you know what, international law says no, we didn't get a resolution, we're going to stay home. They said, no, this is a national security issue. We're not going to delegate it to some nameless, faceless foreign bureaucrats at the Security Council. We're going to do what we're going to do. Now, to the extent that international water law or basically questions about the use of water and water scarcity and water stress combined with climate change is making debates about international water law tied into international security issues, which I think is the direction we're going, and I think many people in the room have certainly seen this in other contexts, then it's less likely on balance that law is going to be an effective regulatory tool. So that's the second. And then the third point, do we think that Egypt and Ethiopia are acting kind of in an incentive-based model, kind of an economics approach that I thought they would? Well, I think we could probably say the following. Through their use of the Declaration of Principles, they're basically memorializing what seems to be a shift from the existing status quo, which is a property regime in which Egypt has an exclusive right, to one in which they recognize Egypt has an entitlement to the water, but Ethiopia needs to provide some sort of compensation. And that's why I emphasize the relevant articles from the Declaration of Principles. One compensation is, we'll sell you electricity cheap. And the second one was basically a commitment not to use the water for irrigation. So it seems like, well, maybe I'm having it both ways. Yeah, they're looking to Declaration of Principles. That is something that looks law-like, but they're memorializing a commitment that has as its kind of underlying core principles, one that thinks about incentives, and the economics approach. So let me conclude with just where I think things are really going to happen. The dam is set to be complete in 2022, but the big issue, and those of you engineers know this much better than I ever will, is the reservoir filling time period. That's the single biggest issue. It's the biggest issue because Egypt would like to see it filled over a 15, 20-year period. Makes a lot of sense. So then, obviously, the reduction in the initial flow is not as severe, not as abrupt, not as quick. So they've said, 20 years is their negotiating starting point. Ethiopia's is 6. Maybe there's room for maneuver here, but that's where the issues will come up. A normal hydroelectric dam over time will not greatly impede water flow, and it's basically the reservoir filling period, and that either 6-year or 20-year period. If it's 6, it will directly threaten Egypt's national security concerns, which might lead them to move in a more aggressive direction. If it's 20, Ethiopia might, vis-a-vis its own people, struggle. So why are we taking so long to exploit resources while our population is growing? Ethiopia is now the second largest country in Africa, and its growth rate is higher than Egypt's. Egypt was the second highest. Now, what's interesting is what's been coming out recently, and there's a few articles now suggesting that Ethiopia has vastly overestimated the capacity of the dam, and that it really will have a very limited impact on Egypt in the end. It's not entirely clear because the reliability of these sources aren't there, but Egypt is certainly taking this quite seriously. So the takeaway is, in 2014, well, maybe economics makes sense. Yes. 2015-16, it seems like they're memorializing it through law. 2019, we're 70% done. So now it's basically to be determined. So we're now looking at 2022, and when we start seeing when they negotiate the reservoir filling period. So with that, I will stop, and I'm happy to take any questions and hear your thoughts on Ethiopia and the dam.